A very good morning to everybody. First of all, I would like to thank PLEA for continuously partnering with Malcolm and giving us this wonderful opportunity to reach out to students and fellow advocates, friends. Contract is something all of us have, at some stage of life or the other, if not entered into a contract, if not drafted one, definitely entered one. If you are on the litigation side, I'm sure you have gone to the court to seek enforcement of a contract. So it's a very interesting topic. And as I said, we would this time we want it to be very interactive. I remember reading Lord Denning's book, and the book started with, in the book, Lord Denning had an entire chapter devoted to the fact that the language is our tool. And unfortunately, we don't seem to be sharpening it enough. Now, how is contracting language, when we draft contract, different from ordinary language? And I know there is uh, great. I'm getting amazing tips in the chat box. There is a growing movement towards what they call de-jargonizing law. So when I say, when we talk about the correct contract vocabulary, I don't intend to promote, go against a de-jargonizing law. What I really intend to say is one clause should not, if you draft a clause, it should not lead to multiple interpretation. Your draft, your language should be such that it reads crisp. Sometimes there are so many wheels within wheels within wheels within wheels in the contract. It's difficult to even understand what's going on. So that is the contract language that you should avoid. Now, in colloquial English, or generally, supposing I was to enter into a leave-in license agreement with okay. So somebody has put up a question in the chat box: how to select the appropriate words. Now, before you sit down to draft anything, be it litigation drafting, be it non-litigation drafting, try to understand the intent of your client. Try to understand the underlying, the underlying consideration, the transaction that the parties intend to enter into, and also do a little bit of homework on your client's business. Now, I was talking about executing a leave-in license agreement. People don't even know that there's a difference between a tenancy, a leave-in license agreement, and a lease. So whatever agreement is on your table, look up the law, do a little bit of research on. For example, once we were asked to, usually car companies also have their uh, also have an NBFC. So supposing Malvika designs a car. Now that car, an EV, for example, and the EV becomes phenomenally successful. So what does she do? Her company, Malvika Automobiles, also floats a NBFC. The main aim of the NBFC is to give finance to the purchasers of Malvika cars manufactured by Malvika Automobiles. So this is a captive financing agreement. So when we had a project like that, in what do we do? So the first thing we did is look up RBI guidelines. There are RBI guidelines which say that loan agreements should be fair. And what would be an unfair loan agreement? There are RBI guidelines which say that in such a agreement, you cannot force the purchaser to take the third party insurance from an insurer of your choice. This kind of clubbing is prohibited by law. So whatever you do, first look up what is the law, look up what are the latest regulations, especially in banking and finance, and especially if you're drafting corporate documents, every day there's some notification or the other which is coming up. Have somebody prepare a checklist of what the latest regulations say, what are the things you should be wary of. Now, that is as far somebody has asked me a very typical. So I'm going to address this. Supriya has put up a very, Suvigya has asked how to select the most appropriate words. Now, it's only when you understand what your clients intend to do, can you pick up the most appropriate words. Coming back to the example of a leave-in license agreement. Now, if you don't specify, I came across a leave-in license agreement in which the lawyer had written, Malvika will give her flat to say Om Prakash for a license fee of say 50,000 rupees. Now this is such a the biggest mistake she did was use a very colloquial term give. Give on what basis? If you use a term like give, now remember uh, this Om Prakash can claim tenancy rights in Malavika's property. So it's very important that you are more specific. The correct language would be Malvika as the licensor grants on leave and license basis her flat situated in this wing, that in this particular building, so on and so forth. And if that intention of the document being a leave and license agreement does not come out clearly, Om Prakash can claim tenancy rights. Then let alone 50,000 rupees, he can go to the court, say I'm a protected tenant under the Maharashtra Rent Control Act, and not even pay a couple of thousand rupees. So therefore, it is very important that first you understand the law, you understand the transaction. There are a lot of templates you will find these days. When I started my practice, we had certain books, precedents, documents, and my typical, my favorite one being deeds and documents. Use those precedents, whether on the net or given in these textbooks, as just as guides. Don't rely on them entirely. No copy pasting. So now, what is the typical structure of any contract? You have the title clause, then you have the recitals, then you have the main body, and then what do you call it? Testimonium, execution. That's it. Now, title clause. When usually a typical title clause, you say X, a company has execute, is hereinafter called party of the first part. Now, this is the worst thing you can do, because if there are 5 parties in your document all the time, you imagine how cumbersome your document will become. Party of the first part, party of the first part has covenanted with party of the second part, and ultimately you will have to prepare a legend only to know which party you have defined as what. The entire idea of definitions is to make your document crisp. So supposing there is a company with a long name, or supposing Om Prakash Vishwanathan. Can you unmute yourself?
I got unmuted myself.
Yes. Now, sir, I noticed your name came on my screen. What is your full name?
Yeah, my name is Om Prakash Vishwanathan.
Okay. Now, usually, which names can be longer, but compared to another name that I see on my screen, Avni, Om Prakash Vishwanathan is more elaborate. So what we usually do, instead of saying Om Prakash Vishwanathan, hereinafter called the vendor, sometimes the transaction is not that of a vendor and vendee, sale and purchase. Whatever the transaction may be, we define the parties as say OV. Another one, there's Mr. Avinash Pujari. You can just call him Avinash or AP. The idea of defining using shorter terms is that to make your document more crisp. I had a client who told me, no, I prefer, I like it better. The other side has defined me as party of the first part, and and himself as party of the second part. So then ultimately both of us realized in that party of the first part, party of the second part, it was really difficult to understand what obligations were assigned to whom. Now we go on to the next part, whether, as I said, you have to marry language with law. So supposing you and I enter into a contract, I did a very interesting contract that was between an artist and a gallerist. Mr. Om Prakash, what is it you do? So in this particular agreement, there was a gallery owner who wanted to pin various artists to their commitment. Now, something like that. You think it's assignable? You think a gallerist can ask, instead of the painter, his wife to paint a canvas? No. Therefore, a typical in this particular case, you will not say, for example, that this agreement is made at Mumbai on this day of dash between Om Prakash and Divya, where Om Prakash is the gallery owner and Divya is the artist, hereinafter defined as the artist, which expression includes her successors and assigns, her heirs, executors, and assigns. Now, for Om Prakash, supposing I die, can he compel my husband to do an painting? No, my husband may not know anything about art or drawing or painting. So you need to leave and license agreements. Now, leave and license agreements, we don't. In Maharashtra, or Maharashtra has some Rent Control Act. All states have a Rent Control Act. And what is the basis of leave and license? That it is not transferable. All licenses are personal to the party holding the license and never transferable. In which case, we don't write that the expression licensee includes the licensee's successors and assigns, because it is personal to the party entering into the contract. Similarly, if you're dealing with a partnership and you say that this agreement is entered into is executed by Messrs. ABC. Tomorrow, if there's a fight, where will you go looking for Messrs. ABC? Because a partnership is not a distinct entity. So what do? You write that this agreement is executed by A, B, and C, partners carrying on business in partnership under the name Messrs. ABC, having its principal place of office at so-and-so place. So that tomorrow, in future, you can, if you have an address to go to, you have the names of the parties to go to. And people, especially, I do a lot of, since my core area of specialization is real estate, I do a lot of, real estate documents. Builders and promoters will never write who the partners are, so that it becomes really impossible to know whom you're dealing with, the parties the real face behind the contract. So that is a very common mistake. And as I said, mistakes start from the title clause. Again, if the party you're dealing with is a Hindu undivided family party, is an HUF. I had a very interesting, had to look at a very interesting point in my junior days once. Karta represents the HUF, whether he has the, who is the right party to execute a document on behalf of HUF. It is the Karta. And at that time, it was common practice to even, include the names of minors and then go on to write that this minor has signed this document through his mother, who's the guardian. See, what are you doing? You're making your document illegal. Instead, when we know that that Karta has the authority to that an HUF is represented by Karta, you mention that. Make sure that the Karta is signatory to your document. The minute you include minors, you run the risk of your document being challenged, because minors cannot enter into contracts. At the most, out of abundant caution, you may make the majors and adults, family members of the HUF, a party to your document. Now, where do we then again address? It's not enough that you just mention Om Prakash and Divya and leave it there, especially in case of company. Of course, now we have the advantage of MCA sites and portals. But under the CPC, under the Code of Civil Procedure, if you have to sue a company, you need to know the registered office. Similarly, you need to know at least know the residential address of the individual with whom you are entering into a contract. Now, recitals. You must have come across that whereas, and it goes on. I have come across documents in which all you read is whereas. So that's when I realized that people don't maybe appreciate what whereas or recitals mean. Can anybody tell me what they understand from recitals and what, according to them, needs to be recorded under the caption recitals? Yeah, so recitals actually means the background. It doesn't mean the background or the facts leading to the actual transaction. And it is for this reason sometimes people, when they start the operative part, say that recitals form an integral part of the yes. Uh, Ujjwala wrote that it is a history, or we say, yes, that's right. It is a history of things. What led to the transaction? And sometimes you actually make the ground for the transaction in the recitals. When I say that Ujjwala, I have decided to enter into this contract of Ujjwala because she has the necessary expertise. It is in the nature of representation to me. If she didn't have that expertise and she didn't tell me about it, I will take it as a misrepresentation. So, but reciters don't report what the actual transaction is. Now, actual transaction between Ujjwala and I may be that of a loan agreement. It may be that if I were a bank or an NBFC, it may be that of, say, a simple sale or purchase. Yes, Ujjwala, you can talk now. So that is as far as the recitals are concerned. Now we go to the main agreement. In my documents, what I capture first, my first clause is always the underlying transaction that Ujjwala, if it's Ujjwala has agreed to sell her flat to me, then that will be the first line for for a sum of rupees so and so. So the actual transaction and consideration, I tend to put it first and very clearly. When you mention consideration and payment, you need to put timelines. You need to specify the method of payment, the place of payment, whether it is, most importantly, timelines. Now, it may so happen there may be certain conditions, conditions precedent, condition subsequent. What are the nature of, what is in a simple agreement? What are conditions precedent? If it's a share purchase agreement, there might be certain corporate compliances. If it's a simple agreement for sale, all agreements, typically high stake agreements, there is a technical, legal, and financial due diligence. So you have a period, a closing prior to the closing of a transaction. You have a period from the effective date till the closing date. The where the parties just don't they carry on business in the ordinary course. You must have heard of something called poison pills. What are poison pills? That sometimes to avoid a takeover, they make the proposition attractive by taking on, the party, the company which is the subject matter of takeover. It will take on a huge debt so that the company becomes unattractive. So from between effective date to closing dates, you can't have these poison pills. So you put suitable safeguards in your document. Similarly, if Ujjwala is negotiating with me for the sale of her flat, see, all titled, all in real estate documents, the title does not pass on until you have a conveyance. So, and this may not anything. Real estate, see, as I mentioned earlier, unlike a pen, pencil, movable property, real estate can be conveyed only by means of a registered vesting document. Now, if it's a sale, then the what we call vesting document would be a sale deed or a deed of conveyance. If it's a lease, then the vesting document would be a lease deed. But prior to the lease or the sale, you have an agreement to lease. So in the agreement to lease, you will say that Ujjwala, Divya will just conduct a title due diligence, issue public notices. So all these you put conditions precedent. Supposing she's the flat that she intends to give me is leasehold property and she needs to take the permission of the lessor, that becomes a condition precedent. Supposing she has more, that property is mortgaged to X and Y bank, either she will have to discharge the loan or takes bank's NOC for dealing with the property. So you need, before drafting, we also need clarity on the entire transaction. Then you advise a client on structuring. In this very simplistic structure, you always have the agreement followed by the vesting document. So this agreement will also outline the conditions precedents. I've given you example of condition precedents, as I said, it can be an NOC from the bank if the property is mortgage. Your condition precedent can be board resolutions that need to be passed. Your condition precedents can be, of course, uh, clear title, certificate of title being clear from the purchaser's advocate. So all these can be once you have decided upon and what are the conditions, which will so far what we are discussing is very specific to the transaction. You move on to the stage of conditions subsequent, which is normally, typically in the nature of registrations and things like that. Shops and establishments, the registration need to be updated. MCA portal, MCA has given a lot of guidelines for. I did a transaction of a company. So we were taking over the company. Our client was taking over a pharmaceutical company. The old board had to resign. We had to appoint our directors. The shareholding had changed entirely. So we had a company secretary working along with us round the clock, who was just updating documents as and when they were being executed. So these are all your conditions subsequent. We had separate, there was the main shareholder share purchase agreement, and more than the main shareholder share purchase agreement, we had a lot of incidental documents, resignation letters, board resolutions. If it's a banking and finance document, you will have your main, for example, a debenture trust come mortgage deed, which then you will have a share pledge agreement. You will have 100 types of undertakings, guarantees, guarantees from personal guarantees of the promoters, corporate guarantees of some group companies. So, as I said, the first thing for you to make your contract foolproof is to understand the structure, is to understand the intent and then focus on the structuring. Right timelines, development agreements, no timelines. If the timelines will be missed, then what? What is important is always think ahead. Now, these you have to provide for, contingencies. When you are talking about, we'll talk about default and breach later. There are a couple of things which I would like to take up first. Conditions precedent, conditions subsequent, possession, handover, taxes. Then we come to the question of representations and warranties. These two are very important. Now, there's a difference between a representation and warranty. We use the term. So when we say that the party covenants and or the party declares and the party gives certain representations and warranties, be very careful because each term has different meaning. A covenant is maybe a nature of the undertaking. What a representation does, and remember, misrepresentation is a defined term under the Indian contract. If you can prove that there was a misrepresentation, it gives the party on whom the misrepresentation, who got taken in by the representation, the right to resign the contract, the right to terminate the contract. But if you say that, okay, I was given this warranty in the contract and it has turned out to be false or misleading or untrue, then you need not necessarily get a right of termination. You may not be able to exit the contract. At the most, it may come down to, identifying the quantum of damages, etc. And you might get the right of reimbursement. So therefore, we use the term representation and warranty. We may use it together, all these terms, but they have different meanings and they give different rights. And then again, to prove misrepresentation is very difficult because it gives the party the right to walk out of a contract. The level of evidence that you have to give is a very high degree of persuasion, very high persuasive value. So that's how you capture your representations and warranties. Be very specific. And sometimes representation and warranties, one clause goes into paragraphs split. For each aspect, you can take a separate a separate warranty. Then usually we tend to club reps and warranties with indemnity. So what is an indemnity? I have simplified my indemnities after reading Garner. Otherwise, if you pick up a very old textbook, the indemnities, they say Avinash agrees to indemnify, keep Divya indemnified and hold her harmless against. There's no need of writing hold her harmless and keep her indemnified. Even if you anyways, he has asked me to keep indemnity out of this webinar. That's the sense that I'm getting. It's in fact, I'm using it as pointers. Now, Avinash has asked me, indemnity means to undertake to compensate. See, again, as I said, if you're dealing, for example, in commercial contracts, have your basics in contract act in place. A lot of concepts and expressions are defined in the Indian Contract Act. I just mentioned misrepresentation because there cannot be any contract without certain representations and warranties. Similarly, the word indemnity is defined under the Indian Contract Act. And what does it say? It says, Dr. Pujari, he very rightly said, undertake to compensate. It's a very long, if you get rid of all the legalese in the Indian Contract Act, it means that the defaulting party will compensate the non-defaulting party. However, you have to be, there's a saying, you have to be damnified before being indemnified. So you have to prove actual damage and then enforce your indemnity. If you have not suffered, there is no way you can enforce indemnity. And enforcement of indemnity too, as I said, is is a bit of a difficult proposition. Therefore, in my documents, I don't stop at indemnity. We write liquidated damages. I have spoken, I think, earlier about liquidated damages. What happens is usually when we are in college, by the time we come to, all these concepts, indemnity, guarantees, liquidated damages, are given in the latter part of Contract Act. And I think by that time, everybody is exhausted. So now Section 73 and thereabouts, I may be a bit wrong. It mentions what is the difference if you read those sections holistically. What is the difference between a liquidated damages and penalty? So I think Dr. Pujari is the only one listening to me. He has mentioned that it liquidated pre-decided amount. Yes, that's right. So a liquidated damages in a very typical, I'll talk about leave and license agreement. Why I have mentioned leave and license? Because interestingly, the Maharashtra Rent Control Act says that if your licensee refuses to, after the license has expired, hand back the flat to the owner or refuses to leave, then he is bound to pay as liquidated damages twice the amount of license fee which he was paying under that contract. So therefore, a very good example where there is a statutory guideline for liquidated damages. I was doing one transaction in which we were paying high level of stamp duty, doing a lot of fit outs. And then in that we wrote that for this particular transaction, what will be the liquidated damages is firstly, if I have to live elsewhere or carry my operations elsewhere, whatever I pay per day. I had a client who started operating from certain offices in a 5-star hotel. So whatever payment, I told him, you tell me what the tariff are, or we decide, and that would be a good estimate of liquidated damages. Sometimes it's very true of government and construction contracts. You talk of escalation because when you give the tender or when you make a proposition on day one, and because of some default, the matter drags on, you have to put a cost escalation in your documents. So as I said, there's nothing before you start drafting, give a day only to understand the client, what the client's intention is, what he wants, look up the precedents, look up the law, try to understand the business, try to understand the transaction. So that's how the structuring is. And I hope everybody has got clarity on what is meant by representation, what is meant by warranty, what is meant by indemnity, what is meant by, now where was I? What was I talking about? Liquidated damages and penalty. See, penalty, which I have mentioned time and again, Liquidated damages, the court does not have to exercise discretion and the court grants it. The specific relief act was revamped in, I think, 2016 or thereabouts. So after the it was almost recast. After the recasting, courts, unless the clause itself is absurd. But as far as penalty is concerned, if you, especially if you read the true interpretation of the section from in the Contract Act, is that then you have to exercise your, the court has to get into the question of what was the damage and how much penalty in the circumstances of the case would be can be correctly awarded. So that is one thing that parties have to bear in mind when you are drafting a contract. As I said, each contract has to be customized. Now, taxation with GST and whatnot, you never know, tomorrow they may come up with a new tax. If you're dealing with property matters, what do you do? So you another point in your checklist is apportionment of taxes. Then we go on to other clauses. Then we go on to default and breach and termination. Very interestingly, breach is we usually provide. See, when you enter into if you are drafting a contract, then it's not, if your people are willing to appoint an advocate for the contract to be drafted, then obviously it's a high-stake game. And termination too comes at a cost. So usually you provide for something called a cure period and have instances of termination specified that for breaches, you can put a general clause, breach of any provision. But for example, there is something which is very important to you. You might have made other commitments based on the commitment of your contracting party. For example, if the contracting party does not pay the license fee on time, so you non-payment of license fee, you specifically mention it. In the contracts that we are coming across, landlords these days are giving are saying that if there's for 2 consecutive months, if there's a default, then the contract, they automatically get a right to terminate the contract. So you have for different breaches, you may give different cure periods. For a license fee which is payable in advance, people know, aaj 7 tarikh aa gaya, I should have paid my license fee before that. If you are an employment, usually termination clause, they insist on 3 months notice period. See, even if an employee is very senior, then they're insisting on around 4 months termination notice. Then you have, for contracts of these natures, you have a non-compete clause. Of course, you also have to be reasonable. If your non-compete clause talks about never being able to work for a competitor ever, and so supposing you're an advocate and you would, you can't have a non-compete saying that, okay, Mr. Pujari can never work for another law firm ever. It won't be upheld by any court. So, but you can have suitable clauses. I came across a very nice clause where the parties in joint venture started a venture. They fell apart, and in their contract, they had written that each party will refrain from doing the same business for a certain period, 6 months, or it will refrain doing this business in this particular jurisdiction. If you know that there's a ball pen called Cello Bic was overtaken. Cello was overtaken by a French company. Later on, the old promoters of Cello, they got into the same business, and that led to a suit. So a non-compete clause in certain cases becomes very important, especially where you're paying a large sum to the founding company promoters to take over their business. Now, if they sell your business to you and the world knows they have the expertise and they, set shop in the same area with your same people, same vendors, same distribution channel, then what did you pay them a hefty sum? So these are the things that you have to bear in mind while drafting any contract. Now just think ahead, think. That's all I can say. And if you have, as I said, if you have sharpened your tool well enough, whatever the fears are, whatever the permutation and combinations that can be, you provide for them in your in your own in the agreement, in the document. So you will come across shareholder share purchase agreements where you have what we call tag along rights, where you call drag along rights. All these rights are in the nature of exit options. What can happen? You and I enter into a joint venture. Things go bad. Either you buy my stake or I buy your stake and close the chapter. But when you talk about exit options, now what is a question that should come to you first? Who will value the shares? How will you come? How will you arrive at the valuation? Simple leave and license agreement. Licensee damaged the property. Something happened. I know of a case. My chartered accountant, he was telling me that he had just invited some guests over, and God alone knows how they use the kitchen, but there was a crack in the platform. So now what do you do? How do you provide for these kind of situations? You will say, okay, we appoint an independent architect to assess the damage, so that obviously the sparring parties will never agree to a amount, and we will go by whatever the architect has to say. Another thing problem is, well, so you put a clause that, in case the licensee damages the property, he will pay, he will make good the damage, etc., etc. But when you sit down for negotiations, this is what it reads like: A shall not pay anything to B. So supposing I say Avinash will pay Malvika. Avinash, in case Avinash damages the license premises, he shall pay. He shall make good the damage by paying Malvika a certain amount. So then during negotiations, Malvika will write, provided that an independent architect has assessed the damage, then Avinash will say, provided that the independent architect is of my choice, then Malvika. So there are so many provisos that at the end of the day, you sit down and wonder what is coming out of it. So instead of putting too many provisos, you split the idea. You split the sentence or the clause into make sub clauses, and that's how you make your document more crisp. The idea of having definitions is to make the document crisp, but these days people define everything. So too many definitions, instead of making a document appear crisp, it makes it look wordy and even more difficult to interpret. If you've defined a term, then you stick to the definition. And it's very typical in Devon license or in leases. There's a good definition of property in the recitals. Then it is captured in the schedule. Then it is captured once again in the main operative part. And then it is captured 100 times throughout the document. You need not do that. Once you have said demise premises, but be very careful. Now, I had also mentioned to Malvika that there are some unpardonable mistakes. Now, what are these unpardonable mistakes? We recently came across a document in which the party had just mentioned land. Now, I can't. Now, in India, we recognize dual ownership. What does that mean? That means the land can be owned by somebody else and the building by somebody else. And that if there was a building existing at the time of the sale, this was not the case where at the time of the sale, the property was a open plot of land. Now, if at the time of the sale, there is a building on the property, but the sale deed doesn't mention it, there are taxation implications. There are, of course, legal implications besides fiscal. What are the legal implications? The immediate conclusion you come to is only land is conveyed, not building. How can I read into a contract something that was not conveyed? And I came across a very beautiful judgment of 1927, Privy Council judgment, which talks about the fact that in India, we recognize dual ownership. So it becomes even more important to mention specifically what is the property which is being sold. Of course, the Registration Act, has what you want to write in the schedule. Under the Registration Act, we are supposed to mention the survey number, the boundaries, and everything. People might wonder what is the significance of these boundaries, because you would want to, and also remember, good fences make good neighbors. If you're written the boundaries, your third or fourth purchaser down the line, he may have to prove what is his land. And at that time, the boundaries are very useful. You annex a plan. Sometimes people just completely forget to annex the schedule or to fill in the schedule. Now, I came across a share pledge agreement in which the schedule of the shares that were pledged, we mentioned the schedule. The schedule was to be annexed separately, and I never got the schedule. So, at the time of proof checking, that's when they realized. That's when we asked for the schedule of the shares proposed to be pledged. Very simple example. Then any other doubts? So that's about it. You have your title clause, you have your recitals, your actual the first when you start your operative part, you start with talking about the actual transaction, the payment, timelines for the payment, conditions precedent, subsequent, timelines for handing over possession, taxes, representations on warranties, indemnity, exit option, default clause, intellectual properties. These days, intellectual property by itself is becoming a major topic. When you are dealing with, we do a lot of contracts for multinationals and foreign companies. So they are very conscious about confidentiality. They are very conscious about this anti-bribery. In fact, while negotiating documents these days, we are asked, why is so a typical anti-bribery clause not only refers to Indian laws, but also refers to UK laws or also refers to US laws. And interestingly, the advocate on the other side asked me that why is the clause so worded when these laws are not applicable in India? See, what is happening is because of Foreign Corrupt Practices Act, if if in US it can be proved that a US company indulged, or in Europe it can be proved, in Europe it can be proved that a European company indulged in corrupt practices in India or in any other country, then they, in that jurisdiction, have to pay a certain fine. So, and the SEC, Securities Exchange Commission, is not sitting tight on this aspect. It's a you will hear, if you read international news, every now and then some company or the other is being made to pay a fine for corrupt practices in other jurisdictions. So therefore, out of abundant caution, all the American companies or all the multinationals, you will notice, have started putting these anti-bribery clauses in their agreements. Then we move on to, at one time, nobody cared much for miscellaneous clauses because it was miscellaneous. And then happened COVID. So what, for example, force majeure, what was a miscellaneous clause, now has become a clause by itself. Now, a typical, and we'll be very careful when we do a copy-paste job. What do you, a very typical force majeure clause is that the obligation which is affected is waived if there's a force majeure event. So since we do a lot of real estate documents, and especially leases and leave and license, which we do round the clock, payment of money can never be affected by any force majeure event. को पैसा भरना है, you have to pay your rent on the 7th. You can't say that because there was COVID, I could not pay the rent. Because there were rains, I could not pay the rent. You can say that I could not, the property got damaged and I could not operate my business from the property. But that does not, when the clause is worded, that the obligation which is affected. So therefore, as far as payment obligation is concerned, you specify it upfront. Don't let it be in this vague language, this blanket language of affected obligation, because there are judicial precedents to say that payment obligations are not affected obligations. So what do? You say, during the subsistence of the force majeure event, the licensee shall not pay the license fee, or to the extent of damage done, or extent to the extent it's unable to, in the ordinary course, access the premises, the rent, the license fee shall abate. So that's an example of a force majeure event, and how incorrect language can, so this happened during COVID, and I was so happy. A lot of force majeure events were looked up and even license agreements examined. And I remember when I was doing this transaction, we felt, do we need to really split hair? But somehow we managed to convince the licensor landlord. This was property in a mall, very high rent fetch, license fee fetching property. We told the landlord, see, there are court judgments which say that payment obligation is not an affected obligation. Therefore, I know this is your standard clause, but we want it to be specifically written that we shall not pay the license fee or the common area maintenance charges during the subsistence of the force majeure event. And this was 2019, 2020 pandemic. We were able to enforce our force majeure clause. Very simple example. And I had two, three other examples, but I think I'll move on to other miscellaneous clauses. Now, non-assignment. The general rule when you read the Contract Act, what comes out of it? All contracts are assignable unless they are in the nature of, where your personal expertise is required, or they are such that they cannot possibly be assignable. I just gave the example of that artist gallery agreement. I gave the example of a leave-in license agreement because of the very definition of the license. So you have to therefore put a specific fetter. See, the general overview is the specific. Therefore, we specifically mention it is not assignable. Now, notice you have to notice you make somebody responsible, mark to somebody. Notice will have to be given to our CEO at this address, and these is everything is being done by email. So we also mentioned the email address. So it may be a miscellaneous clause, but these clauses come to haunt you when the parties start fighting, and if they are not, if you haven't captured that right, that's when you feel the pinch. The other day, I came across a very interesting concept of non-disparagement. When you're doing an employee contract, employees tend, obviously, when your employee leaves, he may have some unhappiness, or he may have got a better opportunity, whatever it may be. People tend to say something about their earlier organizations, rightly, wrongly, you never know. So how do you protect yourself? This is a very simple employee agreement. What if it's a joint venture partner, when the period of joint venture has come to an end? You don't want, or what is, you were scouting for something and the agreement has lived its term. You don't want the other party to say, oh, I was there, it wasn't good, it wasn't run professionally, somebody was given a position, he didn't know anything, this goof up happened, that goof. So you put a non-disparagement clause that no statements will be made to media, no criticism will be made to public. Very interesting concept. So now I have also started putting non-disparagement clauses in my own documents. Confidentiality, which is another very standard. Then further assurances. As I said, a typical, say, you and I might have entered into an agreement to sell, and then we must have done a deed of conveyance. But tomorrow, I want to update the property register card. I want to update government, records so that my name is reflected as the owner. Government may want certain letters from the previous owners. Sometimes we ask the owner to execute a specific power of attorney relating to only the property relating only to the property sold because of these ministerial works. So all that comes under further assurances. That means that the party in whatever they are contractual understanding are, the parties are under obligation to ensure that the other party is able to enjoy the fruits of the contract. And for this purpose, he is bound to execute any NOC, letter, any other document that may be required. So those are further assurances, very common in, again, a very common miscellaneous clause. You have waivers, severability, amendments. Why do we put these? We say that only because I'm not following up constantly with the other party, that doesn't mean I have waived that right. And that's why we state that a waiver, unless in writing, should not be assumed. Similarly, amendment, unless an amendment is in writing, it should not be assumed that anything in the contract by conduct has been amended. And of course, you have interpretation and you have survival. I have some more examples of how to avoid vague and colloquial terms. For example, reversionary rights. I did a very nice transaction where the property was leased out to somebody and a third party told the lessor that, okay, I understand yours is a long lease, but whatever your reversionary rights are, I'm purchasing them. So when you have a concept called reversionary rights, it's defined under law. We know what it means under law. Use that language instead of defining people. For example, your contract. You say it is, use the words specific in that, each party will be able to sue the other party for specific performance. Somebody has asked me, can you please elaborate how to draft force majeure clause? Yes, sometimes your force majeure clause is split into various parts. What constitutes a force majeure is defined. See, what is force majeure? Event beyond your control. But there was a one-time big controversy whether a pandemic or an epidemic too is a force majeure. So now we sometimes make it a point to say force majeure includes strikes and this, civil unrest, wars. You might do an export-import agreement. War would be a force majeure. Floods, pandemics, epidemics. So you define, and whatever you say, specific overrides the general. So whatever you can envision as a force majeure, mention it specifically. Then you go on to say what happens. You can say that for 60 days, you give yourself a 60-day period. 60 days, the neither party, they will wait. If the force majeure event subsists for 60 days, then the rent or the license fee will abate proportionately. And the licensor will try and restore the premises. If there's a leakage, it's not my property, it's the property of the owner licensor. Maybe you give him time to fix it. If he's unable to fix it in, say, 30 days, now you have waited for 90 days. Then you, as the licensee, will exercise your right of termination and terminate the leave and license agreement. That would be a force majeure agreement. So you can modify the force majeure agreement depending on the transaction. And somebody asked me whether a leave and license agreement has to be for 5 years. Earlier they used to do leave and license agreements only for 11 months. Now there are two, three laws which have got all, confused and mangled up, and people have forgotten the origin or the source. The Transfer of Property Act says that leases for more than where the rent is reserved for an entire year need to be registered. So therefore, people used to not wait for an entire year, just do 11 months leave and license agreements. They didn't want their document to be construed as a lease. Then the Stamp Act was spruced up. In fact, earlier even the Stamp Act gave the license fees in the in this 11-month, 12-month slab. Now all that is done away with. See, remember these fiscal acts, stamp duty, these acts don't lay down the law. For the law, you would refer to your Transfer of Property Act or Contract Act. Now, Contract and Transfer of Property Acts are general acts. There will be certain specific acts. Take, for example, in a leave and license agreement, and somebody asked me whether a leave and license agreement will exclude the applicability of Contract Act. For a leave and license is defined under Indian Easement Act. The Maharashtra Control Act talks about certain aspects of a leave and license agreement, but that doesn't mean it excludes the Rent Act, Contract Act. What it really means, Contract Act is a general act where there is a direct clash between a general act and a specific act. The specific act overrides the general act, but otherwise the general act too is applicable. So yes, that was one of the questions.
Divya, in the registration form, we had got one question whether courts allow the parties to rewrite the contracts in case of ambiguity.
Yeah. Yes, you do a deed of. I mean, a contract is, a private treaty. So you can have a deed of supplemental agreement. You can have a deed of rectification. You can have a confirmation. Anything. It happens all the time. Sumed has raised. Yes, Sumed.
Yeah, thank you very much, madam, for the wonderful session. I have a specific question regarding to registration of the property of the land, say, for example, immovable property. If we have executed a document and not yet registered, can we register it in a future date? And what happens if one of the party has expired and still the party who has purchased the land, he wants to register it? What is the remedy for that?
Divya, this
Thank you.
query is not related to today's topic, so it's up to you. I'll leave it to you if you want to address it.
So under law, under the Registration Act, you get 4 months. 4 plus 4, 8. Earlier, the additional 4 months used to be granted as a matter of routine. But these days, you have to make out a case to the sub-registrar that if genuinely we were late by another 4 months because of ABC reason. And as far as the party whose debt is concerned, you implead the heirs. At least you need to protect yourself, because a document which is compulsorily registrable, and all documents in which an interest is created in immovable property are compulsorily registrable. And a compulsorily registrable document, if it's not registered now, the purchaser doesn't get rights to the property. You can get the heirship certificate and the probate, I don't know the particulars of the property later, but immediately to protect your, and there is this matter was challenged. In fact, there's a draft bill of the Registration Act pending in the Parliament, because the Registration Act provides no remedy for missing the boat, unless now you do a fresh document and then you do a confirmation, and so complex. But there's no guarantee that the second time too you won't miss the boat. Yes.
Okay.
Anything else?
Thank you. Thanks a lot. Thank you, ma'am.
What books would you recommend for? Somebody has asked me what books you would recommend for an in-depth study of Transfer of Property Act. To tell you the truth, just if it's coming from a student, then the best way to learn law is to, for example, after a few years, you decide to specialize in real estate. Get involved in real estate transactions. And while, on the job, learn on the job. If there's a certain aspect you are not satisfied with, pick up the transfer of property. I like Mullah and Mullah's commentary, but it's too much to read at a stretch. So, and there is a student's edition of, there are a lot of books on Transfer of Property Act. When I was teaching students, I picked up quite a few, and all of them are quite good. Keep yourself updated. I forget, I don't have it here. I think it's my Gujarat office. I had picked it up for students. Excellent book. Otherwise, as a commentary, I found Mullah to be most effective. And to tell you the truth, Mullah is not being updated regularly. So the one portal that I turn to is India Qanun. It's a free portal. There are a lot of, the world has changed so much. You have bar and the bench. Don't follow the gossip on the bar and the bench. Follow the law and the judgments, and there's live law. There's one other site called Legal Updates, which gives daily updates. Even that is quite useful. Somebody has asked me for LinkedIn. Yeah, follow LinkedIn. I mean, there are a lot of Divya Malcolm, I'm on LinkedIn by that name. Yeah, Mr. Sham, I'm on LinkedIn by that name. But LinkedIn, you get, Mr. Bhumesh Verma has his own page, and he puts up tips on drafting, and he has given us 2 books. He has authored 2 books on drafting. They give you, it's a practitioner's insight into drafting. So they give you exactly what they want. You won't be reading a tome like Mullah's Transfer of Property Act. You'll be reading exactly what you need to have drafting of contracts as a vertical in your firm.
Thank you so much, Divya, for such an insightful session. It was a great learning experience for all of us. Thank you so much.
Thank you, Malvika. And once again, I would like to thank PLEA, and all the very best to you always.